Hi, and welcome to Creepy Crime Story, where the darkest truths aren't imagined. They're real. The ER doors slide open. Headlights smear across the glass. A woman is rushed past triage with a single gunshot wound to the upper body. The man who drove her says it happened in a parking lot. By sunrise, detectives will say the gun fired inside the car. Months later, a courtroom will hear two starkly different stories about how. Fairfax County, Virginia. Late night, April 18, 2024. Inova Mount Vernon Hospital logs the arrival time, the wound location, the immediate interventions. Within minutes, transport is arranged to Inova Fairfax. Medical staff record each handoff. Parallel to that, a criminal file begins. Clothing is removed and bagged, traces preserved, and the vehicle tied to the transport is identified for hold. The intake priorities are basic but non-negotiable: time, place, condition, chain of custody. The account offered at the curb is documented as an unverified claim, a parking lot shooting. That claim sets an early fork. An open lot suggests distance, scatter, potential witnesses, and sound signatures. A vehicle suggests confinement, short trajectories, tight angles, residues that either appear or do not. The difference is not semantic. It governs what technicians expect to find and where they expect to find it. The victim is identified: Allison Kate Laporta, 38, of Lorton. Notification procedures move quietly in the background while detectives step through the first ring of tasks: confirm the hospital timeline, secure the vehicle intact, and cross-check whether any external cameras captured the approach to the ambulance bay. Nothing inferential is added to the record at this stage. If the truth is present, it will be in the geometry of a single round and the surfaces close to it. The man who drove her remains on scene long enough for basic identifiers and a preliminary statement. Counsel and custodial decisions will come later. For now, the emphasis is evidence integrity. Photographs of clothing separations, sealed bags labeled with time and initials, and a signed transfer for the vehicle ensure that what is tested tomorrow can stand in court next year. In quiet suburbs, violence doesn't echo. It lingers. The file must be airtight. You will hear two narratives in the months ahead, one from the state, one from the defense. Tonight is neither. Tonight is intake, establishing that a living person became a homicide victim, that a timeline exists, and that the first story told will be tested against the record. The data align too cleanly. Sometimes that was the problem. Given these first hours, which scenario seems more testable to you, and why? An open lot shot or one fired inside a confined cabin? The name attached to the hospital wristband is Allison Kate Laporta, age 38, Lorton, Fairfax County. Identification is confirmed through government-issued photo ID, hospital intake, and a secondary visual confirmation by staff. Next of kin notifications begin after the medical pronouncement. In parallel, investigators open the first practical window into her life: employment history, address history, phone subscriber data, and recent device activity. This isn't biography for its own sake. It defines what can be verified, where to look, and who must be interviewed first. Employment verification establishes a stable work routine and typical shift hours. That gives detectives fixed points to compare against location records and witness availability. Supervisors and co-workers are contacted for a narrow purpose: last known well, schedule deviations, and any recent concerns. Financial records are not rummaged without cause. Investigators begin with lawful, minimal scope requests, seeking time-stamped transactions that frame movement on the day of the incident. The aim is a clean baseline, not a character portrait. Phone work starts early. Subscriber information confirms ownership. Call detail records and basic tower hits are requested through standard legal process. The focus is confinement around the critical window, not a sweeping history. If a handset is physically present, it is sealed and logged with the same rigor applied to clothing and trace, preserving fingerprints, touch DNA, and latent prints for later. If the handset is not immediately available, the digital perimeter expands to cloud sources, backups, messaging platforms, and account access logs, again within lawful bounds. Each source is mapped on a timeline so that nothing is double-counted or assumed. Social connections are triaged. Close family and a short list of recent contacts are prioritized for welfare information and timeline clarification, not speculation. When a message surfaces in media reports indicating fear close in time to the hospital arrival, it is treated as context, not conclusion. Investigators note the content, timestamp, sender, and path of transmission, then secure originals where possible. The question is narrow. Does the message exist as described, and was it authored by the person named? Authentication steps, header data, device logs, contact corroboration come before any inference. Medical records are handled with restraint. Immediate treatment records are part of the case file because they document injury, interventions, and the time of death. Broader medical history is not narrative fuel. It becomes relevant only if introduced through proper legal channels later. The value for investigators at this stage is the clinical description of the wound as recorded by professionals who saw it first. Range indicators, if any are documented, soot deposits, stippling patterns, will be considered in due course by forensic specialists. For now, intake notes are preserved. Analysis belongs to the technical chapters ahead. Neighbors and property managers provide limited but useful confirmations. Vehicle sightings near the residence in the prior 24 hours, routine comings and goings, and any known security systems that may hold recordings. Investigators ask for retention holds on cameras that might capture the approach to the ER and routes from Lorton to Mount Vernon. These are standard preservation steps to make sure transient data is not overwritten while warrants are prepared. The case advances only as fast as the evidence can be secured without contaminating its value. Throughout, language in the file stays neutral. No motive theories. No labels beyond the relationship already acknowledged in public reporting, boyfriend and girlfriend. The objective is to know the victim in terms that matter to proof, schedule, movements, documented communications, so later forensic work has anchors. Viewers often ask why a life is reduced to records. The answer is practical. Records are the parts a jury can see, measure, and weigh. There is a human line that should not be missed. Colleagues describe Kate as consistent and reliable. Family accounts emphasize responsibility to her children. Those details matter only to the extent they establish patterns that can be tested against the night in question. If a person with a documented routine suddenly breaks it, investigators ask why and look for the record that explains the break. If the routine holds, they ask what intruded on it. Either outcome has evidentiary value, neither is a conclusion. By the end of this phase, detectives have a clean perimeter. Identity confirmed, immediate family notified, work and address histories verified, preliminary phone and account requests in motion, retention holds placed on likely cameras, and a short contact list scheduled for formal interviews. Nothing in this segment answers where the shot was fired. That determination belongs to the physical scene work still to come. But this segment ensures that when a single bullet's path is analyzed, it will be measured against a verified life, not guesses. The investigation moves from hospital paperwork to hard geometry. Detectives test the first account on the table, parking lot, against what can be measured. They canvass the ER approach for cameras, log the arrival route, and secure the associated car under seal. The question is narrow and decisive. Did the gunfire come from open space or from a confined cabin? The answer will control everything that follows, from warrants to charging decisions. Technicians process the vehicle in a controlled bay. Exterior photographs establish baseline condition, panel alignment, glass integrity, door seals, lighting, and any visible impact defects. Each door's inner surface, the center console, the steering column, seat rails, and floor mats are documented before first touch. Swab kits are opened in view of the camera, barcodes scanned to the case, and the interior is mapped quadrant by quadrant, so each sample has a coordinate. This is less about spectacle and more about proof, where residue appears, where it doesn't, and how those patterns line up with ballistics. Within hours, the investigative finding is formalized. The shot occurred inside the vehicle. That conclusion isn't a leap. It's the product of consistent markers you expect in a tight space, localized deposition, distance to target indicators observable in close-range events, and a trajectory that resolves to the car's interior architecture. When technicians recover a bullet from the backseat area, chain of custody begins immediately. The item is photographed in situ, placed in a properly labeled container, and transferred for comparison work. If violence in crowded places can scatter a story, violence in a cabin compresses it. The cabin tells you what happened by what it caught. With the location set, detectives extend the scene outward to the human environment tied to the car. A search near a residence in Lorton yields a firearm. Again, the process is slow by design. Safety cleared, serial noted, photographed, bagged, and submitted for lab analysis. Will microscopic striations on the recovered bullet and test fires from this weapon match? Will tool marks on casings, if casings exist, land on the same pattern? Those answers come later from ballistics. The important point here is procedural. The firearm is recovered near the defendant's residence and enters the evidence stream through documented hands. At the same time, the investigative team works the digital perimeter that was preserved earlier. Traffic cameras are checked for the car's movement window. License plate readers, if present along likely routes, can confirm timestamps, not theories. Cellular records under lawful process provide signal coverage around the period of travel between Lorton and Mount Vernon. None of this tells you why a shot was fired, but it can reinforce when and where the car was in motion, who contacted whom, and how tightly the timeline closes around the hospital arrival. Once the inside vehicle determination is set and the firearm is in evidence, the case moves into a legal posture. An arrest is made. Charges follow: second-degree murder and use of a firearm in the commission of a felony. A magistrate addresses bond. The defendant is held. These steps are procedural. They're not a verdict. They exist because the file now contains more than a claim. It contains a scene that can be walked in court, a projectile recovered from the back seat area, and a weapon recovered near a Lorton address. The standard for charging is probable cause. The standard for conviction is proof beyond a reasonable doubt. Viewers often conflate the two. The system does not. For the family, this phase is invisible but critical. What gets established here shapes what jurors will later be allowed to see. Photographs, diagrams, lab reports, and testimony about collection and handling. A defense will test each step: where a technician stood, which swab touched which surface first, whether preservation protocols were perfect. A prosecution will anchor its case in those same details. In towns like Fairfax County, violent crime is not common enough to fade into the noise. When it does occur, the record must carry the weight of the loss without bending around it. So what does inside the vehicle really contribute? It eliminates the randomness implied by an open lot scenario and points investigators back to the limited universe of people with access to the car at the relevant time. It narrows trajectories to the distances typical of passenger compartments. It dictates where to look for transfer, seatbelts, door pillars, seat backs, and where a bullet might come to rest. And it justifies the next rings of inquiry: who drove, who sat where, and what the medical examiner will say about range when the autopsy is complete. There's a human layer to the precision. Allison Kate Laporta is no longer a name in a hospital log. She's the center of a structured search for truth. The work is dry on paper, but lives are attached to every line in the report: 2 children waiting for answers, colleagues who will be questioned about the final days, and a community that expects the county to be exact. The narrative isn't about spectacle, it's about whether the state can show, with measurements and procedures, how a single round traveled in the confines of a car. As a narrator, I'm asking you to watch the difference between what people say and what a physical space records. The data align too cleanly. Sometimes that was the problem. Was the alignment because the event truly happened in close quarters, or because memory is bending toward the easiest story? That's where good defense work and good forensic work meet, in the parts that can't be massaged, only measured. Before this section closes, the perimeter is set, location fixed to the vehicle interior, bullet recovered from the back seat area, firearm recovered near a Lorton residence and entered into evidence. Digital and camera checks underway to confirm timing. Charges filed under Virginia law. Custody status: the defendant is held without bond. No verdict is implied. The file advances because the scene does not contradict itself. Once the shooting location is fixed to the vehicle's interior, the file shifts from discovery to due process. Fairfax County operates on a predictable track when the facts support probable cause. Detectives draft affidavits, prosecutors review, and a magistrate weighs whether the affidavit's facts meet the standard for arrest. The threshold is not guilt. It is a reasonable ground to believe an offense occurred and a specific person committed it. With the car processed, the backseat recovery logged, and a firearm recovered near a Lorton residence, the case meets that threshold. An arrest is made. The booking sheet is the first official snapshot. Identifiers, charges, and the notation that this is an intimate partner context. The relationship is defined in straightforward terms: boyfriend and girlfriend. That designation isn't gossip. It informs risk assessments and protective measures. Intimate partner homicides are handled with specific awareness inside Virginia's system. Victim-witness coordination is engaged for the family, and any no-contact orders or firearm conditions become part of the docket where appropriate. The label also shapes investigative priorities: communications between the two parties, recent proximity, and the control each had over the car. It narrows. It doesn't predetermine. At first appearance, the court advises the accused of the charges: second-degree murder and use of a firearm in the commission of a felony. Second-degree in Virginia generally captures malicious killing without the elements that elevate to first-degree, such as premeditation under statutory definitions. The firearm count is separate. It recognizes the added danger when a gun is used during a violent felony. Prosecutors do not need to prove those elements at this hearing. They need to show the case has legs, facts that will be tested in full later. The magistrate addresses bond. In a homicide case with the facts now on file, detention without bond is not unusual. From there, the calendar divides into preliminary hearing, grand jury, and pretrial motions. The preliminary hearing tests probable cause again, this time in open court. It is not a mini-trial. Investigators often present a single witness who can speak to the investigative spine: what was found, where, by whom, and how it was preserved. The inside vehicle finding is referenced as a conclusion of scene work. The specifics of range, trajectory, or lab results are typically reserved for trial unless necessary to establish the spine. Defense counsel cross-examines for weaknesses in collection, timing, and the logic that moved the state from a claim to a confined scene. If the judge finds probable cause, the case advances to a grand jury for indictment. Indictment formalizes the path to trial. It also triggers the exchange of discovery. In Virginia, discovery is guided by rules that balance the accused's rights with witness safety and investigative integrity. The defense receives reports, photographs, and recordings that the state intends to use, along with exculpatory material as required. Chain of custody logs for the bullet and the firearm become more than paperwork. They are trial exhibits in waiting. Any gap, any signature out of order, any bag opened without notation. Those are the points a defense will probe later. If a case is going to fail, it often fails on the small procedures that looked minor in the moment. Pretrial motions concentrate the issues. Expect arguments about admissibility, what the jury may see and what stays out. Statements made by the accused, if any, are reviewed under voluntariness and Miranda doctrine. Medical records offered by either side require a foundation: why they matter, what they actually show, and how to shield irrelevant or prejudicial material. Expert notices set the stage for testimony about ballistics, gunshot residue, and range. The court may rule that certain terms are off-limits for witnesses. No conclusions, only observations. This phase is where a clean file pays dividends. Sloppy language in reports can cost credibility that is difficult to regain in front of jurors. Parallel to courtroom mechanics, the relationship context continues to be documented in a measured way. Investigators interview close contacts not to color the jury with character, but to ground the timeline. Recent arguments or calm periods, planned events, and any travel that could explain the car's use on April 18, 2024. Bank card pings and phone records, obtained under lawful process, are aligned to those accounts. If two versions of a night exist, timestamps either pull them together or pull them apart. The point isn't to litigate feelings, it's to anchor movement and contact. The community layer is quiet but real. 2 children lost their mother. Employers and neighbors will sit for interviews they never expected to give. The court is not a grief repair shop, it is a fact-finding process. Still, the system recognizes impact with services and notices. Victim witness staff help families understand hearings and what each one can and cannot decide. That clarity matters because rumor fills silence faster than facts do. Across this period, the state refrains from public speculation. The defense likewise focuses on the record, not noise. The law presumes innocence and assigns the burden to the prosecution. That burden will not be met at a podium or in a headline. It will live and die in the exhibits that trace a bullet's path inside a car, the handling of a gun recovered near Lorton, and the neutral language of doctors and technicians who wrote what they saw, not what they felt. In towns like Fairfax County, murders aren't just crimes. They tear at the fabric of a quiet community. The way to honor that fabric is a trial that is boring in all the right ways. Rules followed, procedures clean, and findings clear. From a narrator's seat, here is the practical takeaway. The relationship label explains why police looked first at the car, the communications, and the proximity between two people. The procedural path explains why the case could be charged when it was, and why it may take many months to reach a jury. Nothing about this phase decides motive or truth. It builds the runway for the evidence to be tested without shortcuts. If you were on that jury, what would you want more, speed or certainty you can defend years from now? With jurisdiction established and charges filed, the next meaningful step is technical. Read the car like a lab bench. Scene techs move the sealed vehicle into a controlled bay. Before anything is touched, a photo grid captures the cabin from every axis, A-pillars to headliner, console to seat rails. Each image is tied to a timestamp and a position marker, so the cabin can be reconstructed for jurors exactly as it was first documented. Trajectory work comes first. Investigators deploy rods and laser alignment inside the passenger compartment to model around traveling through confined space. Seatbacks, door frames, and the roofliner become reference planes. The purpose isn't theatrics, it's geometry. A bullet that stops in the backseat area provides a terminal point. From there, analysts test possible lines backward to the likely muzzle location, accounting for seat positions and recline angles recorded at intake. When the rod paths are consistent across multiple measurements, the team notes it. When they aren't, they document the conflicts and preserve both paths for later expert explanation. Close-range indicators are evaluated next. In vehicle shootings, range can sometimes be inferred by patterns at the wound and by residues on nearby surfaces. Medical examiners will address the wound. The lab addresses the cabin. Swabs target high probability zones for gunshot residue. Armrests, door pillars at shoulder height, steering wheel hub, and seatbelts. Swabs are packaged in sterile containers with bar-coded labels. Blanks and controls are run to guard against false positives. The results don't prove who fired, but they help confirm whether a discharge occurred within the tight bounds of a car, which aligns with the inside vehicle determination already on file. Contact and transfer mapping follows. Technicians look for microspatter or particulate transfer along edges where fabric meets plastic, seat seams, buckle tongues, belt webbing, and the stitching on seatbacks. In a cabin, airflow is limited. Deposits tend to localize. If a deposit exists, its distribution will matter, clustered, directional, or absent where one would expect presence. Absence is not exoneration, but it has to be explained. Each finding is photographed with scale and entered into the evidence log with the collector's initials and collection time. Any later testimony about collection order can be checked against this log. The bullet recovered from the back seat area is treated as a core exhibit. It is photographed in place, then removed with gloved hands or forceps to avoid tool marks. It is placed into a rigid container so the rifling engravings are preserved. The chain of custody form shows who recovered it, at what time, and who accepted it for transport to the ballistics unit. The lab will later compare its microscopic striations to test fires from the firearm recovered near the Lorton residence. If the pattern matches, the state has a mechanical linkage between gun and projectile. If it doesn't, that answer is still evidence and must be disclosed. The firearm's entry into evidence triggers a standard suite of tests. After safety checks, the gun is examined for operability, manufacturer markings, and serial number integrity. Latent print and possible touch DNA collection are considered before heavy handling. Test fires are performed into a recovery tank. The bullets and casings are retained for comparison. If the crime bullet carries clear land and groove patterns, examiners will perform side-by-side microscopic comparison. The result, match, non-match, or inconclusive, will be reported in precise language. Match in this context means sufficient agreement to conclude they were fired by the same firearm, not a percentage. Jurors need clean definitions to avoid speculation. Parallel digital steps are practical, not flashy. Investigators confirm if any interior modules recorded door openings, seatbelt usage, or power states around the relevant time window. Many modern vehicles log limited events, some do not. If data exist, they are downloaded with a write blocker and hashed. Even if the data set is small, an ignition cycle, a door opened, it can tighten the timeline built from cameras and cell records. In a case where minutes matter, a single ignition event can corroborate or challenge a claim sequence. Throughout this work, language in reports stays observational. Observed, collected, submitted, no visible deposition at coordinate. That discipline prevents a later accusation that technicians argued the case on paper. Opinions, range, directionality, shooter position will come later from qualified experts once the lab work is complete, and, importantly, after the autopsy results clarify range at the wound. A clean separation between observation and opinion keeps the file durable. There's a human reason to get this right beyond procedure. Alice and Kate Laporta's family will live with whatever the evidence supports. Jurors, neighbors from Fairfax County, will be asked to decide based on what the car recorded and what the lab confirmed, not on competing emotions. Precision is a form of respect. In towns like this, that matters. If you are weighing this case as you watch, ask yourself what single item would change your mind if it came back clean and strong. A definitive ballistic match from the recovered gun to the recovered bullet, or a medical examiner's range finding that locks the muzzle within inches. Both answers are legitimate expectations. Both require time and a strict chain of custody to mean what they claim to mean. By the time the case reaches open court, the science has drawn a box around the car. What fills that box for jurors is testimony about the hours leading up to the hospital run. The state calls witnesses who place Alice and Kate Laporta and Hui Tien Nguyen together earlier that night. These witnesses describe a bar setting, alcohol present, and the tone of the evening shifting. Their words are not findings. They are accounts under oath taken down by a court reporter and tested in cross-examination. Prosecutors ask narrowly framed questions. Where did you see them? Who was with them? What time? What was said? And in what manner? Several witnesses testify that the argument was heated and that statements about a violent end were uttered. The phrasing matters, so the record keeps it exact. The defense objects when questions drift from observation to interpretation. The judge rules and the jury hears only what the rules allow. No one on the stand offers motive theories. They describe what they saw, heard, and timed against receipts, camera clocks, or their own text histories. That alignment, words tethered to time, is where testimonial value is made or lost. On cross, defense counsel attacks memory and context. Alcohol, ambient noise, and crowded spaces can bend perception. Witnesses are pressed on distance from the speakers, interruptions, and whether the specific words were heard directly or relayed. Inconsistent phrasing across witnesses is highlighted. Consistent phrasing is probed for coaching. The point isn't to win the moment, it's to teach jurors that recollection is a tool with limits. The law allows them to believe all, some, or none of any witness's testimony. That instruction will matter later when they weigh testimony against measurements from the car and conclusions from the medical examiner. Surveillance material, where available, is introduced not to prove emotion, but to anchor time. A camera cannot tell a jury what someone meant. It can show who was present and when they left. When a time-stamped clip places the pair at a location, the testimony around it becomes easier to test. Did the bar tab close at the same time the camera shows them walking out? Do cell records show movement that fits the known route toward the hospital? The state draws straight lines. The defense looks for slack, gaps where minutes are unaccounted for or where two sources of time don't agree. One witness's account typically becomes the hinge. Jurors look for a person with no stake in the outcome who log details without drama. If that person testifies to clear statements about harm, the state leans on it to show escalation. If that person hesitates, qualifies, or says they can't be sure, the defense leans on the doubt. Either way, the bar night narrative is a column of evidence, not the case itself. The cabin still has to speak. The autopsy still has to speak. In towns like Fairfax County, juries take that separation seriously. There is a human cost to putting friends and bystanders on the stand. People who never expected to be part of a homicide file now sit in a courtroom and repeat heated sentences into the record. They will go home and replay those minutes for years. The system asks for precision from them. No more, no less. Precision is also what the family deserves. The defense steps in with a different frame. Allison Kate Laporta died by her own hand. They don't try to relitigate the inside vehicle finding, they accept the cabin and attack what it means. Jurors are told to watch the distances, the hand dominance, and the range indicators that will come from the medical examiner. The argument is clean. If the muzzle-to-wound evidence fits a self-inflicted shot in a confined space, reasonable doubt survives. Records enter through the front door of the rules. Prior medical history, reported as dating roughly 2 years before April 18, 2024, is offered to show state of mind. The court limits what comes in and in what form. Summaries are not enough. Authenticated documents, foundation witnesses, and where necessary, experts translate clinical notes into plain meaning. The defense stresses that these records do not prove intent on the night in question. They open a lawful lane for the jury to consider another explanation consistent with the mechanics of the wound. Then, the rare move. The defendant testifies. Once sworn, the timeline is walked in narrow beats. Where he was with Kate when they left, who drove. On direct, the story is structured to fit the suicide theory. The argument, the alcohol, the confined space, and a moment he says he could not stop. He is asked about prior statements to police and why they changed. He attributes inconsistencies to shock and confusion. He is careful with adjectives and avoids conclusions a lay witness can't offer. The defense wants him to sound constrained, not rehearsed. Cross-examination is the stress test. Prosecutors press the early parking lot account and its conflict with the inside vehicle finding. They work the gap between what he told detectives and what he tells jurors now. The questions target measurable items, timing, routes, positions in the car, and whether his version fits the backseat bullet recovery and any range indicators the Commonwealth expects from the autopsy. If there were threats heard by others earlier that night, the state uses them to argue escalation and access to the gun. The defense objects to speculation. The judge keeps the lane narrow. The jury is reminded of the burden. It does not rest with the accused. A single inconclusive metric will not decide this case, but concordance matters. If the physical data, the medical findings, and the path of the bullet can coexist with self-infliction, the defense says the law requires a not guilty verdict. If they clash, if the angles, distances, or residues contradict that scenario, the state will urge jurors to reject it. Either way, what happens next is not about personalities. It is about whether a human account can stand next to measurements without wobbling. There is a human cost to this chapter too. Families listen to clinical notes and contested memories in open court. Friends watch a private relationship reduced to exhibits and timestamps. The process is heavy, but precision is the only way this can be decided. In towns like Fairfax County, juries are expected to prefer records over rhetoric. That expectation is the point. The case now belongs to the rules. Jurors are instructed to weigh only what was admitted: the inside vehicle finding, the bullet recovered in the back seat area, the firearm recovered near a Lorton residence, the timeline fixed by records. Against that, the defense presents a lawful alternative: suicide, supported by limited, authenticated medical history from years prior and the defendant's sworn account. No one asked the jury to choose a storyline. The law asks them to test elements. If a single essential element is not proven beyond a reasonable doubt, they must say so. If it is, they must say so. That's the job. No narration can redo the science already in evidence. The cabin geometry exists on photographs and diagrams. Collection notes document who touched what and when. Ballistics comparison, if conclusive, will speak in precise language. If inconclusive, it will say that too. Range analysis at autopsy is not an opinion about character. It is a measurement with a margin of error that the court expects experts to explain plainly. Testimony about the evening before is not a verdict by itself. It is a column that must stand next to measurements without wobbling. Jurors are told to take the time they need and to rely on the instructions, not on speculation. What remains constant is the human center. Allison Kate Laporta, 38, mother, worker, neighbor. Families sitting in the gallery are asked to listen to clinical terms because accuracy is the nearest thing this system has to respect. Precision also protects the accused. It keeps emotion from deciding what evidence must decide. In Fairfax County, that balance matters. The same people who shop at the victim's store and drive past the hospital will return to those places after this trial. They deserve to know the verdict, whenever it comes, was built on procedures that can be defended years from now. There is one lesson worth stating once. When a relationship turns volatile and a firearm is present, the risk curve steepens. Document concerns, reach out early, use lawful resources. That is not a judgment, it is a safety tool. If telling this story has value beyond the courtroom, it is in making that tool easier to reach. We will not script an ending the record has not reached. The exhibits, testimony, and instructions are the only path forward, and they are in the jury's hands. As of September 20th, 2025, the Fairfax County trial of Huey Tien and Nguyen remains in progress. No verdict has been announced. I've walked you through one hard truth. Justice is slow on purpose. Precision protects everyone. Kate's memory, the accused's rights, and the community that lives with the outcome. If a relationship turns volatile and a firearm is present, act early. Document, reach out, choose safety. That's not weakness, that's courage. What would you reread first before signing a verdict? The ballistics match or the autopsy range? Tell me your take, where you're watching from, and what this case taught you. If this story moved you, or if you disagree, drop a comment and say why. And if you want more careful, human true crime, please subscribe to the channel.